Hi, I'm Aisling Doyle, an associate on the Employment, Pensions and Incentives team at William Fry. Today, I'm going to give a high-level overview of the adjudication process of the Workplace Relations Commission, more commonly referred to as the WRC. As many of you will know, the WRC is an independent state body that has a number of different responsibilities and functions. For example, it promotes and encourages compliance with employment statute, conducts workplace inspections, and provides conciliation services to assist in resolving employee-employer disputes. The WRC also adjudicates upon complaints alleging breaches of employment rights and entitlements, and I'm going to focus on that process today. Where an individual believes that there has been a breach or breaches of their statutory employment rights or entitlements, they may submit a complaint to the WRC. For example, where an employee believes that they have been unfairly dismissed. Generally, complaints must be submitted within 6 months of the date of the alleged breach, but this can be increased to 12 months, where reasonable cause for the delay can be shown. In respect of most statutory claims, mediation is also available to the parties. A complainant can choose to confirm their willingness to participate in mediation when submitting their complaint form. However, as mediation is a voluntary process, there is no requirement for the respondent to agree to participate. If mediation has not successfully resolved the complaint or has not occurred at all, a hearing date before an adjudication officer is assigned, usually within 6 to 9 months from the date the complaint was first lodged, but this can of course vary. Parties to a complaint are entitled to lodge written submissions, together with all documentary evidence they wish to rely upon, at least 15 working days before the hearing date. The hearing is held in public unless there are special circumstances necessitating a private hearing, for example, where the case involves issues of a sensitive nature, such as sexual harassment. Hearings are usually held in person, but can sometimes be held remotely or can be a mix of the two, a hybrid hearing. While there is no requirement for the parties to be legally represented at the hearing, parties are often represented by a solicitor or barrister, and employees are sometimes represented by a trade union official. Witnesses are sworn in and all evidence is given under oath or affirmation. Preliminary issues, for example, whether the complaint has been lodged in time, are usually dealt with by the adjudication officer at the outset of the hearing, before the substantive issues relating to the complaint are dealt with. At the hearing itself, each party is given the opportunity to set out their respective positions. The adjudication officer will allow each party to make submissions, to give evidence via calling witnesses, and to cross-examine witnesses. Following the hearing, which may take place over the course of a number of days, the adjudication officer will issue their decision in writing. It is open to either party to appeal this decision to the Labour Court, and any such appeal must be submitted within 42 days of the date of the decision. Finally, and unlike in the civil courts, there are no costs orders against either party in the WRC. Each side bears their own costs. If you have any questions regarding the WRC's adjudication process, please contact a member of the William Fry Employment, Pensions and Incentives team. Thanks for watching.